Good afternoon and welcome to today's virtual session on antisocial behaviour injunctions and committal applications. I am Louise Whittington, and with my colleague Natalie Foster, we're going to be considering some practical guidance on how to avoid common pitfalls which we often encounter as practitioners in these type of applications. So the first common hurdle that we often encounter when dealing with applications for antisocial behaviour injunctions is obviously the requirement for personal service. This would obviously not be too much of an issue if the defendant or respondent is in attendance at the hearing, as the court is likely to be satisfied that they've been validly served and that personal service has been effected if they've attended court and are present at the hearing. Obviously, this requirement is set out on the screen at CPR 65.43.5, requirement that the application and all the evidence is served personally on the defendant. It's worth noting the requirement at CPR 65.43.6a, which obviously requires the defendant to be served not less than 2 days before the hearing. And so if the application has been filed with the court and there is a delay for any reason in the documents and the application being personally served, that point and the requirement of 2 days notice may need to be considered, and careful consideration given to whether the court is going to grant the application or an interim order at that first hearing if the defendant does not attend. And so if you are concerned that you've not been able to personally serve the defendant with the documents, there are a number of things that you can consider to ensure that the court is willing to grant the injunction, either an interim injunction or a final injunction at that hearing. First of all, it is a fairly obvious point, but actually evidencing the attempts made by the process server. For example, what dates have they attended? Are there any photographs available of delivering the packet of documents at the defendant's property? What evidence do you have as a local authority or as a housing association that the defendant is actually present in the property? So, for example, if there's been ongoing noise complaints or other antisocial behaviour, and there is evidence of this, that there's actually still issues arising since the application's been filed. And that can be used as evidence that the individual is actually present and at the property and is more likely to have received the documents if they are physically present. Other options can include your housing officer waiting outside the property, although this might not be a very attractive proposition for them. If they choose a particular afternoon, they can then ensure that they are personally served by hand delivering the documents. Other options, again, can include consideration of what engagement there has been by this particular defendant with other services. Have they got a social worker that is allocated to them, or a support worker from a particular charity, or something else that they're engaged with the local authority? For example, if you're a housing association and you know that they're receiving support from the local authority, what emails can you exhibit which shows that this defendant has received the documents by, for example, the documents being placed through the letterbox because they've spoken to their allocated social worker to confirm that they understand that the nature of the application. Something that certainly most practitioners would advise is, if there are any concerns regarding service, drafting a witness statement to deal with these issues. It's worth noting that a judge may not accept submissions made by counsel, as that does not amount to evidence, and they may not be willing to accept simply oral evidence from the tenancy officer that's present at court. In the alternative, obviously an application can be made for substituted service or deemed service. And of course, it may be that a formal application needs to be made rather than simply being made orally at that first hearing. I'd always advise solicitors to consider the very serious nature of these applications, as they can lead, if there are breaches of the injunction, to a contempt of court. And the court may not be willing to deal with the application in its entirety until they're satisfied that the defendant has received the documents and have been personally served. So all efforts should be made to ensure, first of all, personal service, and in the alternative, ensuring that you've got enough evidence to demonstrate that the defendant has received the documents and does have notice of the hearing. In relation to committal applications, which will be dealt with in more detail by my colleague Natalie very shortly, the requirement for personal service again applies. I've set this out on the screen at CPR 81.51. And of course, it's the requirement to personally serve. The subsection at paragraph 2 is that obviously where the defendant has solicitors representing them, different rules apply. And I'd advise solicitors to go and obviously look at the rules. They're fairly self-explanatory there. Something to bear in mind is has the defendant been excluded by the terms of the injunction, and or has any bail conditions been imposed? And so, for example, if you're dealing with an application for committal, has at an earlier stage the particular defendant been arrested at the property and been excluded from that property as a condition of bail? In those circumstances, it's going to be very difficult to personally serve that defendant at the property, and leaving the documents and the application at the property, for example, posting it through the letterbox, is not going to count as valid service. And it's very unlikely that the court will be satisfied that that is deemed service. That is even where we know that a defendant has attended the property, because, for example, they're arrested at the property. It's much better if we know that they've been excluded from the property for any reason, that personal service is affected somewhere else, for example, at a police station following an arrest following a breach. Another point that's worth bearing in mind in relation to committal applications and service is whether, when the defendant is presented to the court following breach, and so of course it's a requirement in those circumstances that they're presented to the court within 24 hours, it may be worth requesting at that hearing, if it's anticipated that a formal committal application will be served, requesting permission to serve that application at an alternative address. The defendant will be present at court, and discussions can be had about whether there's an alternative address where you could deliver the application and any supporting documents. And actually having that foresight at the breach hearing could really help you when you're trying to personally serve the defendant with the committal application at a later stage. Moving on to injunction terms and common pitfalls that we often see in the way that draft orders are prepared. And you will all be aware that it is a requirement to file a draft injunction order with the application and with the witness statement. And so, of course, you're already presenting to the court the injunction terms that you're asking for. And so the first piece of practical advice would be ensuring that the injunction terms are sufficiently clear. And what the courts need to be satisfied of is that the defendant is going to understand what is expected of them, and that the terms are not ambiguous or vague, to allow for a scope of interpretation. So for an example of this could be a requirement that the defendant keeps the property in good or in clean condition. And I've often encountered a judge saying that that term is not sufficiently clear to enable a respondent to be able to know what is expected and what is required of them. My advice would be, if possible, to set it out as a prohibition. So namely, the individual in question is prohibited from allowing particular items to be kept in the communal areas. So rather than it being drafted as a condition to keep the area tidy or in good condition, it can be drafted as a prohibition in keeping boxes or animals or other objects in a communal area, if that is the antisocial behaviour that you're trying to mitigate. Again, it could be drafted as such that the defendant is required, or the respondent is required, to keep the property clear of dog feces. That's an example that sometimes we've encountered, and we're asked to draft or request that that is a term of the injunction if there is a real issue regarding the condition of the premises or the communal areas as a result of that type of antisocial behaviour. The next factor to consider when drafting your injunction and the terms is whether the defendant is going to be excluded from the property. The test for this is actually set out within section 13 of the Act, and it is a very draconian requirement, and it's going to be only granted in very specific circumstances. The test requires, obviously, that the respondent has engaged or threatens to engage or threaten the use of violence against another person, and that there's a significant risk of harm to other persons as a result of essentially from the respondent. It's just a brief note of caution that where an exclusion is being requested, that you've got sufficient evidence to justify the court making an exclusion order. And I would always advise that consideration is given to what other terms can be used to mitigate the antisocial behaviour, rather than asking for an exclusion in the first instance. And that is because the court is going to be very slow to grant an exclusion from the property, due to obviously the nature, the fact that that would be excluding the individual from their home. The next issue for solicitors to consider would be whether any positive requirements are being sought within the injunction terms. And again, what I mean by this is requiring the defendant to do something positively. For example, take positive steps to attend an alcohol course, or requiring them to remove something from the property by a particular date. Again, within the Act, there isn't a requirement for the individual responsible for supervising this positive step is going to need to be named in the injunction. And so consideration may need to be given to whether such an individual is available, and whether it's going to be practical and proportionate to monitor that compliance. And this again links back to what I said a moment ago about the terms of the injunction, that it's much better to draft the injunction terms as prohibitions and requiring or preventing the defendant from doing something, rather than necessarily as a positive requirement. And where possible, it should be drafted as such. Moving on to evidential considerations when preparing applications for civil injunctions, it's always worth bearing in mind the test that the court is going to be applying when considering whether they're going to grant an application for a civil injunction. And of course, the test is whether, on the balance of probabilities, the defendant has engaged in antisocial behaviour. And obviously this is the civil standard, in contrast to an application for committal, which would be on the criminal standard. However, there's still going to need to be sufficient evidence from the applicant or from the claimant, and the burden will be on the claimant to prove the antisocial behaviour and the conduct. And so, depending on the nature of the conduct or the incidents that have occurred, when preparing an application, it may be necessary to have a schedule of incidents, particularly if there has been a large number of incidents, and it's going to be difficult for the court to deal with those if they're presented just simply as a list without being included in a schedule. I would say that a schedule is going to be less pertinent or less necessary in an application for an injunction rather than a committal application. And Natalie will explain further in the second part of this talk. Further consideration should be given to the weight that the court's going to place on hearsay evidence. Of course, in any case dealing with antisocial behaviour, other residents or other tenants may be very reticent and hesitant about providing direct evidence to the court, and it is permitted for hearsay evidence to be included. What must be borne in mind is the relevant weight that the court is going to place on that hearsay evidence. And that's why careful thought should be given to the form of that hearsay evidence and whether it's possible to provide, say, redacted emails from the tenant setting out the behaviour complained of, Or, for example, if there are housing file notes which record discussions with those tenants. And that's going to be better evidence than simply setting out what is said to have happened within the original witness statement of your tenancy officer. It should be borne in mind that if you're relying on very specific incidents and perhaps more limited examples of antisocial behaviour, whether you want to rely on direct evidence from other tenants or residents. The reason I say this is because if there is a contested final hearing and the judge has concern about whether these incidents have occurred or not, of course your tenancy officer can exhibit and can set out their discussions. But if there is any concern, or for example, if a defendant in this application suggests that these incidents haven't happened, you may want to consider whether you want to call those individuals to give evidence directly. Of course, it's going to be a matter for that particular claimant, for example, the local authority or the housing association. And it's really weighing up whether whether the witness is willing to attend court and provide evidence. And I think where there's very limited examples of antisocial behaviour, this may be necessary, and something that if individuals are willing to attend court, that will provide the best evidence for the court to actually weigh up and decide whether they're going to make the injunction final at that hearing. Also, something to think about is whether there's any photographs or video evidence available to substantiate the allegations of antisocial behaviour. Consideration will need to be given to how to present that evidence. Obviously, photographs is slightly more straightforward in terms of they can simply be exhibited, but you might want to have timestamps or deal with how those photographs are taken, when they were taken, and who they were taken by, because often as practitioners we encounter photographs which, for example, they're in black and white. It's not clear when it was taken or specifically what it is of. And the best evidence is always a photograph that's clearly described, is dated, and where there's evidence about how it was taken by the tenancy officer, for example, if they've taken that photograph themselves. Again, just a brief note of caution in relation to video evidence and actually being able to present that in court, and making sure that the defendant has had an opportunity to consider that video evidence. And so when you're serving your application, consideration will need to be given to how you present that, whether that's on a disc or a memory card or sent in another way, to give them a fair chance to obviously consider that evidence. Thank you very much. I'm now going to hand over to Natalie at this stage.
Hello, my name's Natalie Foster, and in this part of the webinar, I'm going to be providing you with some guidance and best practice if you make an application for committal in respect of allegations of the breach of an injunction. So the first thing I'm going to talk to you about is a schedule of allegations or incidents. And in my view, it is recommended to include a schedule of allegations, because if it's done properly, it can be one of the most important documents to include in your application. It will assist the court and provide a summary of your case for the court. They'll be able to see, number one, what allegations are being made. Number two, it will allow you to put together a timeline of what has happened. And number three, you can then identify the types of incidents that you say have occurred. So what we should look at now is, what should that schedule include? And there are various different schedules that I've come across, but in my view, the schedules that best serve the court and best serve the applicant are ones that begin with setting out the particular terms of the injunction. which will also include the dates the injunction, whether it be interim or final, were made, and the dates the injunction's orders were served on that defendant. That's important when the defendant hasn't presented themselves and been a party to the hearing. Once you've done that, I would then set out the schedule. So the first part will be where you list your separate numbered allegations. So I would number them 1 to 5 or whatever, or however many there are. Next, in the next column, I would set out the date and the time, if known, for each of those incidents. That, in my view, helps you and helps the court know how long since the service of the injunction, or how long since it's been made, and the proximity in respect of each of those alleged breaches to each other. So it gives the court an understanding and a flavour of when these things are made and that frequency. The next column should be brief details of that breach. So a summary of the words used, or a summary of the allegation in terms of their conduct. The next column should be when you provide details of where the court can find evidence of that breach. So the affidavit, whose affidavit that is, the paragraph number, and you could provide, if you've got that far, the page reference. And then the next column should be what clause or term of the injunction has in fact been breached. So again, what that does is allows the court and yourself, when considering that schedule and considering your overall case, allows you to look at what types of things have been breached, that what type of conduct is it that we are concerned with. Doing all of this will help you look at whether the allegations you're making are too similar in nature, or whether they could be considered to be a course of conduct or just one breach. So this is important for you in assessing the strengths of your own case, but also will allow you to see what are the most serious breaches and set those out in the best way possible. You can then make a decision to essentially decide whether or not you're going to include each and every breach, or whether you're in fact going to just set out your strongest case and put forward your 5 or 6 strongest breaches to put forward to the court, and then create a more general summary thereafter. The next thing to consider will be the evidence that you want to rely upon. So putting that schedule aside, you have to look at the very earliest stage, who is going to be your witness or witnesses. You need to assess whether each of those witnesses that you need to rely upon, those complainants, are in fact even going to attend court. Some may be perfectly happy to provide written evidence, but in fact may get cold feet when it comes to the actual hearing itself. And of course, these types of cases are prevalent for those who fear identification or fear reprisals. And therefore, real consideration needs to be had as to who you choose to be your witness and how best you can present their evidence. Common issues that arise in respect of witness evidence is that they are, number one, the court could decide to attract very minimal weight to hearsay evidence, and that is evidence that is in your housing officer or your antisocial behaviour officer's witness statement. So, for example, where they have had contact with people or read their file and included that evidence in their witness evidence themselves, or to include evidence that is only supported by a hearsay notice. So a court might decide, in fact, to attract minimal weight to that evidence if that's what you seek to rely upon solely. Secondly, another issue is that the witness might just decide not to come to court, even after they've provided their affidavit and they have given you various assurances that they will attend. They simply might just get cold feet. And another issue is when your hearsay notice has not been properly served. So that's the third issue, particularly that I've come across. And so if your application ends up having one or any of those issues, your application is in jeopardy, because the court is likely to dismiss your application, because what they do is, of course, they consider that what you're doing is making an application to potentially restrict the defendant's liberty. They'll lose that liberty, and you will need to, that's your application, and you will need to prove those breaches to the criminal standard. So the test is very high and the stakes are very high. And so ensuring the evidence is presented in the best way possible is going to be crucial. The things that you can do and the considerations that I say you should have are fourfold. The first is your antisocial behaviour officer or your housing officer, their witness statement can and should properly include where residents have informed them that antisocial behaviour has taken place and that they don't want to be identified, or explain in that statement or that affidavit that information has been heard secondhand. So including it in your housing officer or your antisocial behaviour officer's statement will allow for corroboration later on, allow you to present the best picture in respect of a pattern of similar behaviour or linked behaviour, if that's going to be necessary and appropriate. So I wouldn't leave that out of that housing officer or antisocial behaviour officer's statement. I would keep that there. But then you also need to consider what else you're going to have to support that statement. Secondly, it would be ensuring that when you serve your informants, your witnesses affidavit, those residents or people that are going to come forward and give their evidence but don't want to give oral evidence, you'll have to ensure that you have served alongside the affidavit at the same time that hearsay notice, and also complied properly with the procedures set out in CPR 33.2. So if your witness is not going to be called and you know that witness is not going to be called, then make sure you follow those procedures. The third thing is one that in terms of what I've come across, is that not everyone applies their mind to this. And that is to consider what special measures applications you can make when your case involves a vulnerable or intimidated witness. Chapter 1 of Part 2 of the Youth Justice and Criminal Evidence Act 1999 allows you to deal with and to consider special measures in respect of these committal proceedings. They don't just apply to criminal trials. And so on the whole, largely, you could be at an early age considering whether you consult with your witness about providing that written affidavit, but also allowing them and giving them assurances that you can make applications to allow them to give their best evidence in court, whether that be by way of screens to shield the witness, or another alternative is via evidence via live link or in private. There are various other alternatives set out within the Act, but those are the main and the key special measures that can be considered when deciding whether this witness can give that evidence orally in court to strengthen your case. And fourth, lastly, one of the things, although unattractive, consideration can be had to whether you issue a witness summons. And of course, this is not an ideal situation or position to be in at all. If you need to be in a position to summons your own witness to give evidence. However, it really is going to be a decision that you make as an organisation as to how important is your committal application and a successful committal application going to be to you and to your organisation. Because if it is important, and the seriousness of the allegations that are alleged in relation to the breach of the injunctions, if you consider those to be so serious that you in fact need to do everything you need to do everything to get that committal, then it may be that the unattractive option of a witness summons is a route that you may have to go down. But that's why I've said at the outset that you really need to be looking at all of these considerations at the outset, consulting your witness, assessing your witness and their vulnerability and what they tell you about how they're feeling, and put in place each of these separate steps to ensure that the evidence that you provide is your best evidence. So this concludes the webinar on how to avoid the common pitfalls in antisocial behaviour injunctions and committal applications. Thank you very much for your time. If you do have any further questions or queries, then of course feel free to contact myself or Louise or any of our colleagues within the housing team, and we'll of course be very happy to help you. Thank you very much.